And what ends up happening when a bail amount is set, in Wisconsin, you have to post the entirety of the bail. So in other states, we often hear about a bail bondsman or a percentage. So somebody will call and maybe say, can we just put 10% down? We don't have bail bondsmen. We do have to put the full amount down. And once you put the full amount down, that's when you have what I would call conditional freedom. Meaning, yes, you're out of custody, but you can't just do what you want. You're under conditions, bail conditions such as no contact orders with certain people, no contraband, no firearm, no violations of the law, or can lead to other types of criminal charges.
Are there protections against like how much a state could set for a bail? Like could they just set some outrageous number and they just get away with it?
It certainly happens. I mean, bail is supposed to be reasonable, right? At the end of the day, people are presumed to be innocent, and bail should be an amount that is reasonable. Now, a reasonable amount for one person might not be a reasonable amount for another person. And what courts ultimately consider when they consider bail is the need to protect the public if it's a violent offense, the assurance that the person will appear in court, and ultimately they should consider their financial ability to post and the presumption of innocence and then any defenses that the person could potentially have. But there are certainly situations, especially with violent offenses, where bail can be astronomically high and the person, despite the presumption of innocence, may remain in custody throughout the pendency of the case. And a case can last anywhere as long as 3 months to a year and a half, 2 years.